Hello, everybody. I want to welcome you to the 27th, I'm younger than that, 27th annual Steed Lecture on International and Comparative Law. This year, we are very honored to have as our speaker, Professor Gregory Schaefer, who is both a professor at Georgetown University and the president of the American Society of International Law. I got to know him a little bit through our mutual career in international law, but also in the brief period of time I spent at the University of California at Irvine, where he was for some time. So I'm a long-time admirer of our speaker, and I'm very grateful to him for being here to talk to you about a topic that's also, I know, well, very dear to my heart, but also to many of yours, the concept of the rule of law. This is something that I'm sure many of you have written or spoken about. Now it's all going to be clarified. Before he speaks, I just want to say something briefly about John Steed, in whose memory this lecture is named. John Steed was a British physician who was very active in the Second World War in the convoys that went back and forth across the Atlantic. Out of that experience, he developed a very strong concept of transnational cooperation and justice. And so I think it's very appropriate that this lecture is named in his honor. And I think we would be particularly grateful that we have such a thoughtful and respectable speaker as the one we have today. So our plan is to hear his remarks, which he will keep fairly short, by which I mean about 35 minutes, specifically in order to give you the opportunity to ask your own questions and guide this conversation in the direction that is interesting to you, our audience. So with that introduction, I'm very grateful to have you here, and I give you the floor.
Yeah, thank you, Tim. 1 second, I'm just going to time I wanted to time myself so that 1 second, I'm going to have to restart something. There. Okay. So first of all, it's just an honor to be here, and thank you so much, Tim. And you have such wonderful international and comparative law faculty here, so you're very fortunate. Before I start my talk, I also want to make a pitch. Since I am president of the American Society of International Law, you're at a partner school, which means that membership in the American Society is free for you. And so you should just go online, say you're from Baltimore, and become a member, and then you'll get regular notices. For example, the tragedy that is taking place in the Middle East. As I speak, we just had 2 podcasts on international humanitarian law and the Gaza war. And I find the one that I've already been able to see one that just come out in the last couple of days, or over an hour each. But I can really say the one produced by the American Journal of International Law, which you'll get it's on our website. Take a look at it. I found it's the sort of the most nuanced, balanced sort of presentation of what the international law issues are that's out there. So this is obviously there's so many issues in international law going on today. But welcome you, and then you can come down to our annual meeting and so forth. There are all sorts of advantages of becoming a member. So this right here, at the end, if you're interested, there's a paper behind this, but the paper is actually a long introduction of a book. And the book is forthcoming from Cambridge University Press. And it's my particular take on the rule of law with respect to how we think about international law in connection with the rule of law. And so just to sort of put this in context, this is the World Justice Project, just showing declines around the world in terms of rule of law indicators. And you see this consistently over the last, say, 15 years or so since they started doing these measures. But these are also backed up by what Freedom House, you can see significant, especially plummeting indicators in terms of rule of law protections around the world. And this is a decline in democracy indicator. So in parallel, you see these declines. This is the V-Democracy website where you can find this all documented, their annual reports. And so it really raises a question, right? if we see all these indicators moving in parallel, and this involves not just sort of, it involves all types of regimes. So not just transitional democracies, not just authoritarian regimes, which are actually, you see reductions within authoritarian regimes of rule of law protections, but also full-fledged democracies, you see these declines. And so is this just by chance, right? Just by happenstance that we see this, or is there something which is transnational, right? Which actually, there are indicators which cut across countries. And if so, what explains them and what might be done? So the framework which I use, the central argument of this lecture and of the book is that there are interconnections, that we shouldn't be seeing these in isolation. And it's actually a mistake if you're going to address rule of law concerns to turn inward. That international law is, and international institutions are now under challenge. They're threatened, and they provide important normative and material resources for rule of law protections within states. And so the declines you're going to see, the argument is, in parallel at both the domestic level and the international level. And it's tied to a series of books that I've produced on thinking about international law, not purely at the interstate level, but in terms of its interconnections with what happens at the national, the regional, and the local levels. This is just an example of its application in international trade law, where you really see this one regime among many, which really is in terms of commitment to legal norms, or invocations of security exceptions to securitization of all of this. Just in the decline of law and legality is I think, connected to broader trends. It's not isolated. So the lecture today is really going to be in the introduction, the framework papers, in 4 parts. One is just, what do we mean by the rule of law? And I'll say a little bit more about that, but I don't think, it's interesting, just talking to my daughter who's older, sort of like rule of law, I think for the general public in terms of, why does it matter? What's important? Justice matters, right? Or democracy matters. But what rule of law sounds like lawyers, it sounds rather technical and so forth. And the argument is it's actually a very critically important public good. But what do we mean by it? And I think to think about it in terms of legality or legal checklist is a mistake, right? Actually, they ask, what's the rule of law? To conceptualize it, you have to ask the question, what's the point? So what, right? And the answer to the so what question is that what the purpose, the goal of the rule of law is to protect against the arbitrary exercise of power. And when you see it in those terms, then the next question is, what's the problem? If the problem is the arbitrary exercise of power, what are the sources of this arbitrary exercise of power? And then once you address the sources, then you can start to think about how do you conceive of practices that would provide institutional checks on those sources of the arbitrary exercise of power. So that's section 1 in brief. Section 2 is, really then thinks about how do we think about international law in terms of these rule of law protections. And it'll make 3 core arguments that international law is embedded in broader transnational normative systems. International law, first of all, is central for peace. And peace is sort of the starting point. It's a basic answer to the Hobbesian question. And if you don't have that, the rest you can forget about. Second is, you think about international law, not just in terms of its direct impacts, but its indirect impacts in terms of providing normative resources for domestic actors within states. And it's how international norms diffuse and become embedded. Ultimately, international law matters most if it becomes embedded in norms and practices and taken for granted conceptions within states. And third, if we see these empirical trends that I started with, and which go into more detail in that section of the paper, what explains them? And talk about a little bit that, and you might have other questions and feedback on that. And then fourth, what might be done? So in terms of conceptualizing, what we mean by the rule of law. And I've started to do that right now and talking about it, but I want to say a few things just in terms of sort of caveats when we think about the rule of law. And I think the reason why many people, from a popular perspective, just have difficulty. It seems a little bit abstract. What do we mean by the rule of law? And one is that we need to distinguish rule of law from concerns about the substance of law. I mean, we all know that the powerful are very well positioned to determine the substance of law. So if we just collapse the rule of law in terms of law and legality, right, it sort of misses the point about the arbitrary exercise of power. Because if you can ensconce sort of arbitrary norms within law, and I'll put up some slides about that, then the rule of law simply becomes a rule by law. It becomes a tool to wield power. And we can think about this just in terms of critical approaches with respect to class, with respect to race, with respect to gender, and other attributes, right? And so just to give you, say a little bit more about this slide, it's a wonderful film. If you haven't seen it, watch it, see if you can get it on Amazon Prime or whatever. It's a Russian film. It's filmed in the sort of up in the Baltic Sea, in the northern, above the Arctic Circle. It's a small town, and it's really a story about how the local power holder, in this case the mayor, uses law to destroy an individual, right? Not to protect the individual from the arbitrary exercise of power, but uses the legal system, court cases, judicial investigations and so forth to destroy someone. So obviously the rule of law is a different conception than simply following the law, right? Here, just to turn to our own country, right? The rule of law is not just legality, because of course it would be illegal for the young girl to go and drink from the water fountain or to go and sit in the front of the bus, right? And so we'll talk about this too. But it's very critical to differentiate the conception of the rule of law from simply law or following the law. The rule of law also, I want to make the argument, is that it's not just a question of an easy checklist, right? And you'll see the Venice Commission, I greatly admire in Europe, has come up with rule of law checklists. But authoritarian regimes know very well how to create forms, right, that look like they have checked the box, right? But then they use those in ways which actually subvert and undermine rule of law practices. So and you see this also in the concept, this came out of the United States during the Iraq War, of the concept of lawfare, right? And we have a popular blog on lawfare. That law then is just an instrument. It's a tool, right? Just one other tool like war itself, right? And I think that doesn't capture at all what the rule of law is all about. So then if we think about the rule of law, the question is, what are the sources of arbitrary? If the rule of law is conceived in terms of the arbitrary exercise of power, what are the sources of arbitrariness? If you have others, glad to hear what they are, but here's 5, right? So one is just simply when the rule of law doesn't apply, right, to the leader, right? You see right now a trial with a former president who says that, no, the rule of law doesn't apply to, the law doesn't apply to the president, right? What I did while I was president, including if it's trying to subvert an electoral outcome, is simply that I have immunity. Right? The rule of law doesn't apply to the leader. And this, of course, is the famous interview with Richard Nixon where he says, when the president does it, that means that it is not illegal by definition. Okay. The second source of the arbitrary exercise of power is when we simply cannot, as individuals, know what the law is, right? So that we can plan our activities, so that we don't fear that the state, for some reason, can come down on us for any reason, right? And so that's the reason why you see sort of you see this in different checklists, which is that the rule of law should be published, right? It should be transparent. It should be consistently applied, right? It should be only prescriptive and not look to prosecute you for what you did before the law was enacted. It should be relatively stable so that we can just get on with our lives, right? A third source of arbitrariness, and Lon Fuller sort of set these out in a very famous book, Morality of Law, which I highly recommend. It's another legal philosopher, Joseph Ross, who really talked about then the that the important check of arbitrariness is you have no place to be heard, no place to contest through the exercise of authority over you. And so there's an important institutional dimension to the rule of law, checks and balances and so forth. And Jeremy Waldron, another philosopher, legal philosopher, stresses the importance of the need for contestation to ensure the rule of law. A fourth dimension of the rule of law is with respect to just the use of reason giving, right? And this is a photograph of the most famous interwar theorists, and my view is that we risk being in sort of an interwar period right now, in terms of both the rise of social inequality, precarity, as well as tensions, right, which are rising in the formation of blocks of countries. This is Carl Schmitt. He eventually became a member of the Nazi Party, and he theorized law in terms of decisionism. Law is just a series of decisions, right? And the importance is who makes the decisions, right? And law has no normative power because rules, in this famous quote, prove nothing. It's the exception to the rules that prove everything. The exception is more interesting than the rule because it's he who decides the exception who rules. Okay, so reason giving is something is central to the rule of law. And then finally, just that, and this is the issue of proportionality, right? And the relationship of means to ends, right? So, do you give 18 years of prison, right, for something which clearly, one, is just a cooked up crime, but even if it was a traffic violation or something minimal, you see how law can be wielded in disproportionate ways to basically prosecute any opposition or any threat to your power. Now, once we think about this, obviously in these different dimensions of the rule of law, that you can have states that look like rule of law regimes in certain areas, such as in commercial and business law and administrative law. China has made immense strides in these areas of law, right? And this is theorized in a very famous book after World War, with respect to the rise of the Nazi regime, in terms of viewing Germany as a dual state, that for business, for capital, that you had rule of law type institutions to protect contracts and so forth. And you see this in states today because they want economic growth, right? They want discipline through administrative law. But you also see it, of course, in the United States, as I referenced earlier. You could really see the United States as a dual state, especially during the Jim Crow era, where you had different rules that applied to blacks and applied to whites. So if we then think about this, how do we think about the international rule of law from a transnational perspective in terms of transnational legal ordering? So I already mentioned that, we should start, the basic contention is that international and national law, we're going to see them moving in parallel. And that's what we see today. That to the extent you have more robust rule of law institutions and practices within states, and you see movements in this direction, you're more likely to see more robust rule of law protections at the international level. And to the extent that you have states that are concerned about the constraints, the normative constraints created at the international level, then the more likely they're going to want to check the scrutiny of international institutions on their own national behavior and remove those normative resources for their own populations. And so you could see these checks in parallel. And so one central role of international law, the whole purpose of the United Nations and the UN creation of the UN Charter was to foster peace after the great two world wars and to outlaw, except for very limited contexts such as self-defense, the engagement of war, right? So war became illegal except for purposes of self-defense or as authorized by an institution, a multilateral institution, the Security Council. But you also see that many other international institutions foster this goal. So just to give an example, because to go quickly in terms of the International Court of Justice, if you study international law in the United States is very different than studying it in other countries, because other countries actually do rely on the International Court of Justice. And in fact, there's been an explosion, right, of litigation before the International Court of Justice over the last 10 or 15 years, which most Americans wouldn't know and would ignore. But this, just in terms of, think about the counterfactual, if you had no international institution to try to resolve boundary disputes. I mean, boundary disputes are central to armed conflict in the history of war, right? And this is just a list of all the boundary disputes cases that have gone before the International Court of Justice, the Permanent Court of Arbitration, and this is the law of the sea. So these are both maritime and land boundary disputes. And 85% of them actually resulted in full or partial compliance. Okay? So counterfactually, if you didn't have that, then you would have ongoing tensions. And the reason why states do this, you can imagine, is because for their own domestic populations, they can say, it was a contested boundary, but we didn't just give up territory. Rather, we did our best to advance our position, and we lost. And so now we settled this case, right? And we settled the boundary. Okay. A second way to think about the role of international law and institutions is their indirect normative role. So ultimately, what's very important is if international law comes home in domestic practices. So if you just take in domestic law, so the Universal Declaration of Human Rights has been the most influential piece of paper on constitutions around the world. You document what rights are provided in national constitutions. They come from the Universal Declaration. And there's an explosion in terms of creating these rights within domestic constitutions through it. But it's just one of many different examples, right? So if you think about all the transnational networks of NGOs and so forth, and all the different international institutions that don't necessarily create binding law, but they expostulate what norms are. Norms, they cross-reference in international human rights institutions and regional courts. But they also then can be referenced, including by the US Supreme Court in some very famous cases, such as recognizing that it's illegal to prosecute people based on their sexual orientation, right? And you had international norms cited. But what made it so powerful was that it was the United States Supreme Court that made this decision. But by referencing international norms, it also provided legitimacy, right? And so legitimacy not only for decision makers, but also for a general public. If you do surveys of people and you ask them a question, you'll get a response to that question, which will maybe be 50-50, let's say. If you ask them the same question after telling them that this is what international law provides, the questions are very different, right? Their answers are very different, right? And so it really frames the way people think, what's legitimate, what's not. It's a powerful normative resource. And so the person who actually spoke as our keynote speaker last year at the Grotius Lecture at the American Society of International Law, Kim Lane Shepley, she's assessment of international courts, she said we should see them in three-dimensional space, that international courts should not be viewed hierarchically as super appeals courts or primarily as backstops to national courts, but rather as part of broader normative orders. Okay. That horizontally among themselves and vertically in relation to national courts affect institutional practices, particularly for the protection of the rule of law. So, I mean, if you study law in Latin America, the Inter-American Convention of Human Rights is actually part of how you study constitutional law. Right? In the UK still today, we will see, because there's pressure to remove it, that the UK Human Rights Act, for example, requires UK judges to interpret statutes as far as possible in ways that are compatible with the United Kingdom's international human rights commitments. Okay? And this is true in many countries around the world. Third, And this is just, there's a wonderful book by Sally Mary, an anthropologist, a legal anthropologist on gender violence with respect to the interaction between, she did field work both in the United Nations and at the local level with respect to gender rights, and talks about how you navigate those and how activists try to localize international norms so that they can be effective in their local spaces. But of course, international law finally also has direct effects, in many areas around the world, in Europe, in Latin America, and in Africa. It's the possibility of bringing claims directly to human rights courts. This is the European Court of Human Rights. That's the Inter-American Court of Human Rights. Here's the African Court of Human and People's Rights. And these institutions, I think they're now many of them are under attack, right? In sort of the name of sovereignty and protecting against infringements of sovereignty. But they also, importantly, because they became so much more robust in the last 15 years, they still provide for institutional and normative resources to push back against authoritarian trends and movements within countries. You see this in Mexico, you see this in Brazil, you see this in many countries around the world. And so the book contains case studies from different countries around the world. Okay, so that raises the question then, what explains, and I gave you the indicators at the beginning, some of these. And the book says, argues that we can see both virtuous cycles of rule of law protections increasing at the international level and the national ones, and we can also see vicious ones. And we're in a vicious cycle now of backtracking. And the main argument is that it's a combination of both internal and the interaction between both internal populist forces and anti-globalist backlash against the international order, which has upended domestic politics in many countries. If I should probably add a slide before this of the American firsters with not only, this is currently, right, but it actually came back from the interwar period. In fact, those were signs. The Ku Klux Klan used to walk around with one God, one country, right? One race, right? And America first, right? It's even more dangerous today, and you see this not only in the United States and Brazil, these movements wrapping themselves in the flag, right? And it's like we are the ones who are Americans, not them, right? And them, which would be many people perhaps in this room, including me, are the enemy, the enemy of the state, right? The media are the enemy, or any media that critiques or scrutinizes what I do are enemy of the people, and you are the people. And the sort of us versus them language, which we see developing. And so, the United States during the last administration, it withdrew from the Paris Agreement on Climate Change, the World Health Organization, United Nations Economic, Social, and Cultural Organization, the UN Human Rights Council, and threatened to withdraw from the World Trade Organization. So it was across international organizations of withdrawing and moving internally. At the same time, externally, I could show you another slide, which just shows the rise of authoritarian governments in terms of their role in the global economy, which provides them with leverage, right? And so China now is actually bigger than the United States in terms of measured by purchasing power parity in terms of its economy. But if you just saw it also in terms of nominal values, right, it's just become so much more important, right? Just in the US and Europe, they've relatively declined. Okay, so I think it's these interaction of shifts in the international level in terms of the rise of authoritarian regimes or authoritarian governments and affecting international regimes, and the rise inside countries of sort of these nationalist, in our case, sort of white Christian nationalist, sort of us versus them type populism. Because populism in this conception is both anti sort of elite, which means anti any sort of checks and balances, anti-institutions, and it's also anti-pluralist. It's like there's one way of thinking, and so in that sense, it's against core democratic values. pluralist values. We can disagree, but if we disagree, we can still try to get along, as opposed to imprisoning the other. So in what we saw, this is, of course, there was a major shift in the 1990s and 2000s. You saw indicators then were increasing around the world, and now we see them decreasing. And I would just mention 4 trends in terms of international law: attacks on international courts. You see this in Europe. You see this in the Inter-American Court, again, in the name of sovereignty. In the name of security, national security, which is national security is the foremost invocation of sovereignty, right? And if everything becomes securitized, then there's no normative role for international commitments whatsoever. Second is going to be just a turn away from treaties. Now, I've written binding treaties and binding obligations and the move to sort of soft law instruments. I'm a believer in soft law, but one of the challenges is when much of this becomes non-transparent. So you don't even know within our own country what agreements are being signed by the executive branch, right? What sort of deals are being done. And so there's something just about basic democratic accountability that you know what the law is, right? As opposed to that you see these practices being developed non-transparently. The third is the neutering of international institutional scrutiny. So attacks on sort of the Human Rights Council, any sort of scrutiny of reporting in terms of what you're doing domestically. And a fourth is to harness international law norms for purposes of supporting repression. The war on terror provided all sorts of possibilities for authoritarian governments to, quote, apply UN Security Council resolutions in order to adopt domestic laws and regulations to oppress and repress. China now is one example. Of course, it became when irony became, it's put its nationals in charge of more international organizations than any other country in the world, but it was also in charge of the International Police Organization and of course it's been pressing for extradition treaties in order to extradite any critics of the regime. Of course, it has great economic leverage with respect to neighboring regimes to extradite, say, ethnic minorities and so forth, which it views as threats. But also, it's you see these laws being adopted in the name of international law, right? And so I think with the rise of authoritarian governments in power, potentially, as my friend and colleague Tom Ginsburg has written on what is an authoritarian international law, an authoritarian international law will be used to repress, right? Cooperation to extradite, quote, criminals and so forth. The creation of standards for sort of technologies to be able to identify and control population. Okay. I think these are interconnected because this is an example. This is when the Office of the Human Rights Commissioners finally did a report on what was going on in Xinjiang. The Chinese spokesperson from the foreign ministry's response was that the whole commission is a thug and accomplice of the West, right? So you see sort of this move, and I make an argument with respect to Putin and his war on Ukraine, that when he attacked Ukraine, if you watch the speech that he gave domestically, right? He talked about the West as being a threat to Russia's traditional values, and he specifically mentioned LGBTQ rights, right? That the fact that these were traditional values were under challenge, and that we need to then, of course, this is self-cleanse Russia, the opposition. These are scums and traitors that should be spit out like a midge. Okay, so you see sort of this sort of idea that these values at the international level, they do provide, and the fact that Ukraine, actually, you had anti-corruption authorities who were trying to have Ukrainians who, NGOs and so forth, because there were lots of problems, let's be honest, in Ukraine, and there still are, right? But you had activists pushing Ukraine in a more democratic, liberal tradition and trying to foster ties to Western Europe. And that was a threat, in my argument in the paper, is to Putin's own internal control within Russia. And so the domestic and the international are interconnected. And here, we have a picture from the war in Ukraine. So what might be done? I mean, I'm going to say four things. I mean, first is, we can't turn inward. We have to combat, we have to address rule of law issues, both domestically, which are critical, but also we can't think it's just domestic issues and it's time to just, think about our own domestic problems. We have to work on all fronts simultaneously. The second is that Biden has created this, quote, Summit for Democracy, which I find, on the one hand, to be important, sort of upholding the norms of democracy and rule of law, but on the other hand, very dangerous, right? Because it really turns the world into blocks, and it gives a sense, and it's actually, it's part of, much of this is driven by U.S., quote, security people who want to isolate China, want to isolate. And what that does is it creates incentives for those countries naturally to feel threatened, to create blocks such as a new axis between China and Russia because they're allies, because this bloc is against them. And if you actually look at the interwar period, Japan also felt that it was under threat and being cut off economically. And so that it needed to expand its sphere of influence in Asia to protect itself. Right? So it can be dangerous. The third is to me, central, is that domestic social policy is central to what's going on. And so the rise of job precarity, of social inequality to levels that we haven't seen since the 1920s and 30s is linked to these attacks on rule of law institutions here and internationally. This is a wonderful, powerful book about deaths of despair from addiction and so forth of those who have been left behind. The fourth, and this, of course, is really just sort of an economic explanation. The fourth is how do we think about culturally? And I think it's the most difficult. People really do feel that their way of life is being challenged, that somehow their status is being challenged. My own response is that cultural and the economic are interlinked. When people feel like they're more at risk, their jobs are more at risk, their livelihoods are more at risk, they're more likely to take these cultural tropes such as white identitarianism and so forth that you see rising in this country. And so I'm just going to conclude that, in short, from a rule of law perspective, I think international law matters in very powerful ways. And it's a different way of thinking about international law than the conventional one in a conventional public international law casebook. It's really then thinking about international law and its interconnections with what happens about the domestic level. Because for me, ultimately, the rule of law is not so much about interstate relations. It's about interstate relations insofar as they affect the arbitrary exercise of power over individuals and groups. And it's that normative resource that international law provides. And so I'm just going to conclude with a wonderful article that recently came out by the philosopher Kwame Anthony Appiah, who writes, as populist demagogues around the world exploit the churn of economic discontent, the danger is that the politics of engagement would give way to the politics of withdrawal. Forgetting that we are all citizens of the world, a small, warming, intensely vulnerable world would be a reckless relaxation of vigilance. Elsewhere, Appiah writes, has never been more important. So yes, ours is a small world and a vulnerable one. When we work to defend and advance the rule of law within our countries, let us not forget the transnational links with and role of international law, so that we can move back from a vicious to a virtual cycle for rule of law protections against the arbitrary exercise of power. Thank you.
Thank you very much, Professor Shea, for extremely perceptive and persuasive remarks, and also for very kindly leaving time for questions from the audience. So I call on the audience for any questions they may have that they may be inspired to ask after hearing this fascinating talk. You do whatever you want to do, Stan.
If people can hear, right, yeah.
So hey, thank you for giving this lecture.
Yeah.
It took me a bit to write this question because then I started thinking of questions about the question.
so bear with me. How might the current cycle of viciousness that we're going through, especially when we're thinking about American populism, be combated to undo the delegitimization of international legal institutions and agreements, especially when we're thinking of in the context of interstate conflicts occurring on the rule of law? So like one thing that I'm thinking about is you're seeing these conflicts between our different states where the rule of law is not only challenged but being questioned on what grounds it stands, which therefore kind of leads to this continued challenge and just erasure of the rule of law at the international scale. So I mean, it's a very loaded question, but how do we go about like undoing and I guess getting us back in the right direction towards thinking about international rule of law?
Yeah, and so that's the fourth section of the paper, tries to go into more on that, but also giving lots of citations to that. We've developed this much more broadly. So I do think, central to this is that I don't think it's any, just by chance that we have levels of inequality and levels of social precarity that we haven't seen since the interwar period. And the sort of attacks on, this, as you recall, during the interwar period, the United States refused to join the Versailles Treaty, and it withdrew. The isolationists were quite powerful. So I think that it's it's multiple fronts. The domestic front is really to provide opportunity so people don't feel threatened and feel at risk, and so they're less susceptible to populist arguments. I think at the same time, and I think then there's a question about the calibration of international law. So where I've written, which is actually, it's not necessarily the question is more international law everywhere. So for example, one could think about international economic law, which is one of my areas of specialization, I'll say, that as you move towards a sort of a neoliberal model of free movement of capital, what it did, in my view, is that an empowered capital vis-a-vis states, because capital could simply, one, it made it possible to park all your profits in jurisdictions with very low tax rates, which meant that it became more difficult to fund social welfare programs because you simply don't have the same tax revenue, and you always are under pressure to cut taxes because you're in tax competition with other states. That can only be, I think that can be resolved by one, the United States, certain domestic, has to take the lead on this. But two, you need international coordination to try to address this. So that's a different way of thinking about, international economic law than just free movement of capital flows. The second is, once you did free up capital flows and trade, you created the challenge. One, it created all this. It's difficult because you see in many Asian countries and in China in particular, there's a huge number of people who were able to be removed from extreme poverty. And so that was a great advance. But at the same time, it meant that capital was empowered vis-a-vis labor, because capital could always just threaten or actually go elsewhere unless labor cut its demands for wages and so forth, which of course also then led to higher inequality or so forth. So that's a major challenge. I think the Biden administration is trying to work on this with its new initiatives, but it can also be viewed because it becomes also linked with sort of the securitization against China. So everything in a sense becomes, I'm a critic of I'm not a China hawk, obviously, that everything, even our climate change policy now it's sort of climate change plus don't let China be able to benefit in any way from any regulations based on imports that are, reduce greenhouse gas emissions. I think that's a mistake. I think, and it was actually nice to see the other day, I don't know if you saw, they just signed through the G20, a declaration with respect to the dangers of artificial intelligence. Prime Minister Sunak in the UK was criticized for including China. And his response says, you're not going to address these dangers with like artificial intelligence if you don't include China, right? And actually, China's doing a lot, and we shouldn't just think that everything China is doing that we can't learn from. They're creating all sorts of scrutiny with respect to AI that, I mean, are clearly using it also to suppress, but it's a complicated state of 1.4 billion people with many different ministries. We shouldn't just typologize it as sort of like, it is moving in authoritarian directions under President Xi, but there's lots of opposition within China to those moves. And so, but we empower those moves by creating a sense that China is always an existential threat. So I think there's people, I think, within the Biden administration who understand that policy needs to be more nuanced, but there's also incredible domestic politics, political pressures to never, accommodate China, right, or to be viewed as soft on China. And that's going to, so you can see once again, is sort of the domestic dysfunction of our politics right now. And I think, addressing inequality is will at least remove some of those pathologies.
Another question. Yes, come on.
So my question has to do with the decline of democracies, democratic backsliding in the United States. I think the United States, it can't be denied, played a big role in creating the norms at an international level and a great deal of impact on international law. And if you look at the world and it's becoming more multipolar, the United States is having to do something which Professor Sellers hates, which is IR, and he calls the devil. But we have to make decisions about allying ourselves sometimes with these backsliding democracies. And so my question is, what is the incentive structure there at of them behaving with the rule of law if we're incentivizing their democratic backsliding? Although at the national security level, we're thinking about great power competition.
Yeah, so I think one of the big battlefronts right now that really will take a lot of thought is the securitization of everything. So what is national security, right? There's a wonderful article in Agel about different conceptions of national security. Is climate change national security, right? If climate change is national security, then suddenly we need to think about China in very different ways. If pandemics are national security, then we need to think about China in very different ways and international institutions in very different ways. And so I think there is a pressure to securitize everything, steel and aluminum imports and so forth, any sort of trade with China. If everything becomes a question of checking China, right, I think that we undermine the prospects for cooperation. And you see this with respect to, I would say, Chinese of liberal persuasion, who I know, right, who say, wow, it seems like you're always attacking us. You're trying to destroy, our prospects for prosperity. And I think there's a real risk with that because you do also create this us versus them. And so the National Security Council is probably the most important. It's in the White House, so it's not a separate department, but it's very powerful right now, and it'd be actually the most fascinating place to work right now, because it's those debates there which are going to determine U.S. policy and determine alliances, such as you referenced. And it really then becomes a question of how do we conceptualize what we mean by security. And if we do so, we're going to have very different views in terms of who we need to work with.
Wahil?
Thank you so much for your great lecture. We really learned. Since I have studied my master's in democratic governance and rule of law, so it's really relevant. I have also some similar experience in Afghanistan. So Martin Krieger, in his book, The Rethinking the Rule of Law After Communism, he says that there are some prerequisites that every nation needs to have rule of law in a country, and that prerequisites, for instance, includes like self-incrimination, the fundamental rights, having a good constitution, and enshrining that fundamental rights within that constitution. So in the meantime, for instance, in the book How Democracies Die, like Levinsky and Zebolt says that when democracies die because rule of law doesn't work in that country, for instance, the power or the president of a country, or maybe a country is being authoritative, and they are somehow assigning for instance, justices and chief justices, then the checks and balance doesn't work in that country, or the separation of power doesn't work in that country. It means that rule of law doesn't work in that country, and in this way the democracy died. So the question is, there are two theories. In the meantime, one theory, we need some prerequisites to have a rule of law. In the other theory, we have the main aspect of democracy, which is rule of law. If rule of law doesn't apply, the democracy doesn't apply in a country. So in these two instances, how rule of law survive under a conflict kind of state, conflict zone, or a long conflict kind of dealing zone like Afghanistan, like in other nations. And even as per Levinsky, he says that even rule of law under fascism and populism also doesn't work, because, for instance, like our President Ghani, our Afghanistan President Ghani was, a populist. He was saying a lot of things. He was a big talker, but doing very less. So it means that he was monopolizing the power and doing nothing for the rule of law in the country. Or, for instance, there are other instances in the country now, the conflicts that's going on now in the world. So the question is how rule of law, or what aspect of rule of law should be taken serious to have like a rule of law in a country under conflict zones. Thank you.
Thanks for that. Great question. So I don't think the two approaches of Krieger and how democracy dies theorists are necessarily in conflict. I think they're linked. But let me just say a few things first of all about Krieger. So if any of you have yet to read Martin Krieger, to me, he's the best theorist on the rule of law out there, and he's a wonderful writer. His pieces are relatively short. He's actually writing the conclusion for this book, and my whole conceptualization of the rule of law all builds from Krieger. Okay. Now, Krieger's point is that rule of law is an ideal, a very important ideal, but it's instantiated in practices. And because it's ultimately instantiated in practices, there has to be a habit, right? There has to be a cultural norm, right? In which these become very important, right? And so checklists, legal checklists are not sufficient. And of course, that's the most difficult to reach. It can take long periods of time to reach those. I think institutions, to tie in the second point, are very important in helping to create those dynamics in terms of shifts in cultural norms and practices. But they can be very, very difficult. And so the idea that you're going to helicopter in with a rule of law checklist for your new constitution and your new institutions and what the law says can have zero impact. It can just be pieces of paper. And that's Krieger's point. We need to always keep the goal in mind. What's the point? Then we have to address what the problem is from a sociological perspective. And then we have to think about means. And those means include institutional means. The point in terms of the relationship between the rule of law and democracy that you pointed to, I think, is central. Because if you think about it, you can have democratic elections, right? But it all comes down to what takes place in the polling booths, who's counting the pieces of paper and the votes, right? Are they governed by the rule of law? If they're not, then democracy just becomes a facade, which we see around the world today. Everybody today says we're a democracy, we have to have elections, right? Russia has elections, right? Countries around the world now have elections, right? But of course, it all depends on the validity of those elections on the rule of law.
So we're coming to the end of our allocated time. I see 3 questions on this side of the room. So my suggestion is that we ask the 3 questions
think that's
rather
great.
sharply,
Yes.
giving you a collection, and then you'll get an answer, and then I'll give myself the last word. That's the plan. So the 3, I can see right in a row, 3 people. Why don't we start in the back and work forward?
So I guess my question relates to the fact of how do you work within the fact that many of these international institutions are kind of fundamentally designed to prioritize the needs of certain countries over others. Like the UN Security Council is probably the best example where you have, the veto ability where, the US, Russia, China, France, UK can all basically shut down any discussion they want to, regardless of what, the rest of the world wishes, or, the IMF works similar. Like you have, many of these institutions are basically designed in such a way to, give other countries advantage over everyone else. And I guess how do you make that, work within that framework?
Yeah.
Okay, in reference to the Summit for Democracy and Domestic Dysfunction, where do you recommend we start when attempting to dismantle the us versus them dualistic views that are so prevalent in this country, and get people to realize that all these issues are way more nuanced than just a Democrat, Republican, or any other kind of dichotomy we have going on in this country?
Hey, so I had a very similar question there, but also a follow-up. I said, my question is, if you agree that the UN Security Council member unilateral veto power is a major impediment to the rule of law at the international level, if so, how do we get away from that dangerous status quo? And so the follow-up is, if the US and the Western Bloc, generally speaking, do regularly use their veto power to make sure that they or their allies on the world stage can never be held accountable for international law violations, then why is a country like China wrong when they call these international institutions a performative facade to advance Western interests?
Thank you for the very easy questions. The first and the third, right? So first of all, just in terms of the own rule of law definition and sources of arbitrariness, the UN Security Council by definition, right, is a violation of the rule of law in the sense that the law doesn't apply to the powerful. Right. Second, we shouldn't think about international law any differently than national law. It can be used in abusive ways as well as in positive ways. Third, international institutions also can exercise arbitrary power over individuals. If you think of the UN Security Council resolutions seizing assets with no due process of individuals. Fourth, how to think about this then is to think about it in transnational perspective, that international institutions are not the only ones in the transnational field, also domestic ones are, and regional courts. So in the latter example is the European Court of Justice in the Cadi case, which decided that the Security Council regulations, they could not adopt them because that would violate European Union law. And they decided that within their own case, but when they did that, that created pressure on the Security Council to, one, create an ombudsperson, and two, to revise its regulations. Now, it didn't create perfect rule of law practices. There are a lot of problems with the current current situation. But the idea is that we should think about this as a dynamic transnational process, which can not only involve international institutions disciplining national ones, but also pressures from below on international institutions themselves. And there's a chapter in the book on the UN Security Council, which says, this is basically written by Australia and New Zealand, who are not powerful states, that we're not going to get rid of the veto power, but these are the different things that we can do as non-powerful states within the Security Council to create checks. Second, and I think those are the first and third question on, how do we dismantle this us versus them, right? And that's such a difficult question. What I tell you what I'm doing now is that I'm reading a lot more psychology than I used to. And it's a wonderful, I can't remember the title of the book right now, but it starts with the story of abortion activists. My wife, you might know, Professor Michelle Goodwin, is sort of a leading reproductive rights activist and scholar. The book is about in Boston, where you had anti-abortion activists who believed very strongly, right, in their views. But what happened was there was, of course, a murder, right, violence of doctors who are under threats all the time. When we have people over to our house, we can't announce that. I mean, they're literally under threat that they could be. In fact, my wife receives death threats, right? But what they did was these different women they tried to create a space where there were certain things off limits, right, such as violence, right? And they didn't change their views. They didn't change their views, but they actually engaged, in they recognized that in a pluralistic world that they were going to hold on to their views, but there was difference, right? And there's something about that which was quite powerful. And I don't know, we intensely, view with respect to reproductive rights, and I'm not going to stop that. And the International Law Society is one of the issues in which, we have many speakers and panels and so forth. But I think, the idea of just creating spaces where we're able to talk as opposed to demonizing the other and seeing them only as the other and us versus them is so important. But creating those spaces, right, really is a question of both political and domestic psychology. And there are people, Haidt and others, who are writing on this. And that's anyway where I'm reading for insights as opposed to telling you what we should do.
So now, I'm getting ready to thank our speaker, but I want to have a run-up. Because in my enthusiasm at the beginning, I didn't start out by saying on whose behalf we're thanking the speaker. So I see in the room Dean Colin Starcher, Dean Gastelvik. So first of all, on behalf of the university and our administration, we're so glad that you're here. Secondly, the Center for International Comparative Law, my co-director, Nienke Grossman, who's come in specially for your talk. She and I thank you. Associate Director Turko Koriti thanks you, and Janet Lord, who joined the team yesterday, thanks you. Also, and perhaps most importantly at all, a great many people in this room are students at the University of Baltimore. First of all, you're beautiful. And I thought your questions were great. Thanks. Professor Schinkler is going to stay after for a while, and all these teams of the fighting reception are going to start as soon as I finish talking, and she will have the opportunity as other professionals. I hope you've seen in our lives how grateful we are for the lives, how much good they were, and the lives people react. I look forward very much to the book. Thank you for coming. And now the forbidden word.
Yes, all right.